Hi, this is MARYNHOR, and I'm going to introduce to you the Title 9 of the Revised Penal Code Book 2, titled Crimes Against Personal Liberty and Security. To begin, the first chapter discusses crimes against personal liberty. What is crimes against personal liberty? These are the offenses that limit an individual's freedom to do as he pleases, but only to the extent that his actions are regulated by the authority of a politically structured society in the public interest. So, Section 1, Illegal Detention. It is the unlawful deprivation of a person's liberty by arrest of a wrongful case. Now, I'll discuss the first article in this title and my colleagues will discuss the others. Article 267, titled Kidnapping and Serious Illegal Detention. So, kidnapping and serious illegal detention is committed when a private individual kidnaps or detains another, or in any other manner depriving of his liberty, when such detention is illegal and it is committed in any of the following circumstances. So, if the kidnapping lasts for more than 3 days, if it is committed simulating public authority by pretending to be a public officer, if threats to kill have been made upon the person kidnapped or any serious physical injuries inflicted on the kidnapped person, and if the person kidnapped or detained is a minor, female, or a public officer. It is important to note that the person who violated this article is a private individual, since if it is a public person, it falls under Article 124 or arbitrary detention. And for the penalty, death shall be imposed if the purpose of kidnapping is to extort ransom from the victim or any other person. So what is ransom? Ransom is the money that given for the redemption of the liberty of the victim. And also, when the victim is killed or dies as a consequence of the detention, or is raped, or is subjected to torture or dehumanizing acts, the maximum penalty shall be imposed.
Article 268, Slight Illegal Detention. The penalty of reclusion temporal shall be imposed upon any private individual who shall commit the crimes described in the next preceding article without the attendance of any of circumstances enumerated therein. This article shall be imposed upon any private individuals. The elements: number 1, that the offender is a private individual. Number 2, that he kidnaps or detains another or in any manner deprives of his liberty. Number 3, that the act of kidnapping or detention is illegal. 4, that the crime is committed without the attendance of the circumstances enumerated in Article 267. Liability mitigated with: number 1, offender voluntarily release the person so kidnapped or detained within 3 days from the commencement of the detention. Number 2, without having attained the purpose intended. And last, number 3, before institution of criminal proceeding against him. Penalty: the penalty of reclusion temporal.
Article number 269, Unlawful Arrest. This article penalizing any person who commits the acts defined therein, whether the person is a public officer or a private individual. As one mentioned under Section 6, Rule 11 of the Revised Rules of Criminal Procedure, a private person can arrest an individual without warrant under the circumstances when public officers can make arrests. If a private person conducts an arrest without reasonable grounds, as defined in Section 6, Rule 113 of Revised Rules of Criminal Procedure, and the objective is to transfer the detained person to the right authorities, he is accountable under this article. There are 3 elements existing in this article. First, that the offender arrests or detains another person. Second, that the purpose of the offender is to deliver him to the proper authorities. And last, that the arrest or detention is not authorized by law. General rule: when an arrest is authorized by court, there is no unlawful arrest. The court has issued a warrant. So, detention is not legally permitted, and unlawful arrest is committed by making an arrest not authorized by law. With regards to its sanction, a penalty of arresto mayor and a fine not exceeding 100,000 pesos as amended by Republic Act No. 10951, August 29, 2017.
Article 270, Kidnapping and failure to return a minor, shall be imposed upon any person who: number 1, that the offender is charged with the custody of the minor person, whether over 7 years but less than 21 years of age. Number 2, that he deliberately fails to restore the said minor to his parents or guardians. and the penalty of the said crime is reclusion perpetua. But the crime is committed by the father or mother of the minor, the penalty is arresto mayor or a fine not exceeding 300,000 pesos or both.
Article 271, inducing a minor to abandon his home. This article shall be imposed upon anyone. Elements are 1. That a minor, whether under or over 7 years of age, is living in the home of his parents or guardian or any person entrusted with his custody. Number 2. Offender induce said minor to abandon such home. Inducement must be A. Actual and B. Committed with criminal intent. Father or mother may commit these crimes under Article 270 and 71 where they are living separately and the custody of the minor or children has been given to one of them. The penalty of which is prison correctional and a fine not exceeding 1,000 pesos.
Article 272 is slavery. Anyone who shall purchase, sell, kidnap, or detain a human being for the purpose of enslaving him, if the crime be committed for the purpose of assigning the offended party to some immoral practice, the penalty shall be imposed in its maximum period. The elements are that the offender purchase, sells, kidnap, or detain a human being. And second, that the purpose of the offender is to enslave that human being. The penalty shall be imposed in its maximum period. Penalty of prison mayor and its fine and a fine of not exceeding 10,000 pesos.
Article 273, exploitation of child labor. This article shall be imposed upon any person. This article can be violated if the offender retains a minor in his services. Also, if it is against the will of the minor. And lastly, if it is under the pretext of reimbursing himself of a debt incurred by ascendant, guardian, or any person entrusted with the custody of such minor. Let us note the phrase against the will of the minor. If the minor consents the offender's retaining his services, there is no violation in this article. So the penalty in this article is a penalty of prison correctional in its minimum and medium periods and a fine not exceeding of 500 pesos.
Article 274. Services rendered under compulsion in payment. This article shall be imposed to any person. The elements of Article 274 is that the offender compels a debtor to work for him either as household servant or farm laborer. That is against the debtor's will. The purpose is to require or enforce the payment of debt. The penalty of arresto mayor in its maximum period, prison correctional to its minimum.
Chapter 2, Crimes Against Security, Section 1, Abandonment of Helpless Persons and Exploitation of Minors. Article 275, Abandonment of Person in Danger and Abandonment of One's Own Victim. The penalty of arresto mayor shall be imposed upon 1. Anyone who shall fail to render assistance to any person whom he shall find in an inhabited place, wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. Number 2. Anyone who shall fail to help or render assistance to another whom he has accidentally wounded or injured. Number 3. Anyone who, having found an abandoned child under 7 years of age, shall fail to deliver said child to the authorities or to his family, or shall fail to take him to a safe place. Acts punished under the Articles 275. First, by failing to render assistance to any person whom the offender finds in an inhabited place, wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. So the elements of the crime is first, the place is not inhabited, Second, the accused found there a person wounded or in danger of dying. Third, the accused can render assistance without detriment to himself. Fourth, the accused fails to render assistance. Another act punishable under the Article 275 is by failing to help or render assistance to another whom the offender has accidentally wounded or injured, and by failing to deliver a child under 7 whom the offender has found abandoned to the authorities to his family, or by failing to take him to a safe place. Any person whom he shall find wounded or in danger of dying. Thus, if a person intentionally wounded another in an inhabited place, paragraph 1 of Article 275 is not applicable because he did not find him wounded or in danger of dying in that place. Omission constituting a more serious offense. The last paragraph of this article provides that the penalty of arresto mayor shall be imposed unless such omission will constitute a more serious offense. Example, if the offender who failed to render assistance to the person in danger of dying in an inhabited place have the custody of such person and is a minor under 7 years of age, and the minor died as a consequence, the penalty of prison correctional in its medium and maximum period provided in the second paragraph of the Article 276 shall be imposed with this aggregate penalty. Paragraph 2 of Article 275 applies only when someone is accidentally injured by the accused. Note that the word accidentally in this article, hence, if a person intentionally stabs or shoots another who is wounded and he did not render him assistance, that person is not liable under this article. He is liable only for the crime resulting from the stabbing or shooting, which may be physical injuries or homicide if the victim dies. Must the offender know that the child is under 7 years? Under the third way of committing the crime is immaterial that the offender did not know that the child is under 7 years of age. Thus, paragraph 3 applies to the one who found a lost child. It would seem that such child also needs same protection that the law intends to extend the abandoned child. For the praise shall fail to take him to a safe place, the child under 7 years of age must be found by the accused in a safe place.
Article 276, or abandoning a minor. This article shall be imposed upon any person or anyone. The elements of these articles are that the offender has custody of the child, that the child is under 7 years of age, that he abandoned such child, and that he has no intent to kill the child when the latter is abandoned. And also remember that anyone who will be received or anyone who will be punished by this article will receive the penalty of arresto mayor and a fine not exceeding of 100,000 pesos. But if the abandonment caused the death of the child, the offender will receive the penalty of prison correctional in its medium to maximum period, but only if the life of the child is threatened or endangered. The penalty will be prison correctional in its minimum and medium period only.
Article 277, or abandonment of minor by person entrusted his custody in deference of parents. This article shall be imposed upon any person. Punishable acts under Article 277 are first, by delivering a person or a minor to a public institution without the consent of the one who entrusted or without the consent of the proper authorities. Second, by neglecting his children to attain or giving them education even though the financial status or financial income of the offender is enough to afford it. There are 3 elements of abandonment of a minor. First, the person or the offender is charged of the rearing or education of a minor. Second, he delivered the person or a children to a public institution or other person. Lastly, the one who entrusted that children to the offender has not consented to such act. or if the person who is entrusted to the child is absent, the proper authority has not consented it. When it comes to indifference of parents, it contains 4 elements, such as: first, the offender is a parent. Second, the offender is neglecting his children by not giving them education. Third, his station in life requires education and his financial condition permits it. And for the last element, the failure to give education must be accordance to deliberate desire to evade such obligation. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who violates this article. Also, same penalty shall be imposed to those parents who neglect their children by not giving them education.
Article 278, Exploitation of minor imposed upon any person. Prohibited acts. Number 1, causing boy or girl under 16 to perform any dangerous feat of balancing, physical strength, or contortion, the offender being any person. Number 2, employing children under 16 who are not children or descendants of the offender in exhibition of acrobat, gymnast, rope walker, diver, or wild animal tamer. The offender being an acrobat, etc., or circus manager, or engaged in a similar calling. Number 3, employing any descendants under 12 years of age in dangerous exhibition enumerated in the next preceding paragraph. The offender being engaged in any of said callings. Number 4, delivering a child under 16 gratuitously to any person following any calling enumerated in paragraph 2, or to any habitual vagrant or beggar, the offender being an ascendant, guardian, teacher, or person entrusted in any capacity with the care of such child. Number 5, inducing any child under 16 to abandon the home of its ascendants, guardian, curators, or teachers to follow any person engaged in any calling mentioned in paragraph 2, or to accompany any habitual vagrant or beggar, the offender being any person. Penalties. The penalty of prison correctional in its minimum and medium period 6 and a fine not exceeding 500 pesos shall be imposed upon.
Article 279. Additional penalties for other offenses. Imposition of the penalties prescribed in the preceding articles shall not prevent the imposition upon the same person of the penalty provided for any other felonies defined and punished under the Code.
Article 280. Article 280. Trespass to dwell. This article shall be imposed upon any private person. First, the element. Number 1, the offender is a private person. Number 2, that he enters the dwelling of another. And number 3, that child entrances against the latter's will. The provision. The provision of this article shall not be applicable to any person who shall enter another dwelling for the purpose of the preventing some serious harm to himself. The occupants of the dwelling or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, nor to anyone who shall enter caves, taverns, inn, and other public houses while the same are open. An example: the exemption is when you are being chased by anyone who is a threat of your safety and you seek refuge to entering a house of someone you don't know. If the offenses be committed by means of violation or intimidation, by penalty shall be prison correctional in its medium and maximum periods to fine not exceeding 1,000 pesos.
Article 281. Other forms of trespass. When an offender or banned person accesses another person's locked property and the trespasser has not obtained authorization from the owner or caregiver. It refers to the room, business, building, or a specific region, but in the any instant location instead. A penalty is a fine of arresto menor or fine not exceeding 40,000 or both may be imposed upon violators of this article.
Article 282, Grave threats. This article shall be imposed upon any person and its elements are the following. First, that the offender threatens another person with infliction upon the latter's person's honor or property or upon the latter's family of any wrong. Next, that such wrong amounts to a crime. Third, that there is a demand for money or any other condition is imposed even though not unlawful. And the last, that the offender attain his purpose. The penalty for this article are the penalty next lowering degree that prescribed by law for the crime he threatened to commit. It is when the offender shall have made the threat demanding for money or imposing any other condition even though not unlawful, and the said offender shall have attained his purpose. And if the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. The penalty of arresto mayor and a fine not exceeding 500 pesos if the threat shall not have been made subject to a condition. In the crime of threats, it is essential that there be intimidation. In the intimidation, there is a promise of some future harm or injury either to a person's honor or property of the offended party of his family. And according to its circumstances, if the threat is made in writing or through a middleman, the penalty to be imposed in its maximum period.
Article 283, Light threats. The elements are: number 1 is that the offender makes a threat to commit a wrong. Number 2 is that the wrong does not constitute crime. Number 3 is that there is a demand for money or that other condition imposed even thought not unlawful. Number 4 is that the offender has attained his purpose or that he is not attained his purpose. The penalties in this article shall be punished by arresto mayor.
Article 24, Ban for good behavior. In all cases falling within the 2 next preceding articles, the person making threats may also be required to give bail not to molest the person threatened, or he shall fail to give such bail. He shall be sentenced to destierro. Destierro means prohibition on accounting, entering, or exiting an area or within the radius designated when a person is required to give bail bond. Number 1. When the threatens another under the circumstances mentioned in Article 282. Number 2. When he threatens another under the circumstances mentioned in Article 283. Any person who shall threaten another with infliction upon the person, honor or property of the latter of his family, of any wrong amounting to a crime. Article 282, RPC.
Article 285, Other light threats, which shall be imposed upon any person those prohibited acts. Number 1, threatening another with a weapon or by drawing such weapon in a quarrel, unless it be in lawful self-defense. Number 2, orally threatening another in the heat of anger with some harm constituting a crime without persisting in the idea involved in his threat. Number 3, orally threatening to do another any harm not constituting a felony. Article 285, the penalty of arresto minor in its minimum period or a fine not exceeding 40,000 pesos.
Article 286, Grave coercion. This article shall be imposed upon any person. Elements of Article 286. Number 1, that a person is prevented by another from doing something or not prohibited by law, or compelled to do something against his will, be it right or wrong. Number 2, that the prevention or compulsion is effected by violence, threats, or intimidation. And number 3, that a person who restrains the will and liberty of another has no right to do so, or in other words, that the restraint is not made under authority of law or in the exercise of any lawful right. The crime of grave coercion is punishable with arresto mayor, imprisonment from 1 month and 1 day to 6 months, and fine not exceeding 500 pesos. Said offense comes within the area of concurrent jurisdiction or municipal or city courts and courts of first instance. For example, the case of Bong Navarro versus Cedric Lee and Denise Cornejo. We all know the story of Bong Navarro versus Cedric Lee and Denise Cornejo. Cedric Lee forced Bong Navarro to remove his pants for Cedric Lee to show in the video that Bong raped Denise Cornejo, and because Bong doesn't want to do what Cedric Lee says, he threatened that he and his family will be killed if Bong Navarro didn't do what Cedric Lee says, and it is admitted to the crime grave coercion.
Article 287, Light Coercions. These are the elements of light coercions. Number 1, that the offender must be a creditor. Number 2, that he seizes anything belonging to his debtor. Number 3, that the seizure of the thing accomplished by means of violence or a display of material force producing intimidation. Number 4, that the purpose of the offender is to apply the same to the payment of the debt. These are examples of light coercion. Kiko saw Mark park his motorcycle. Then Kiko demanded Mark to pay his debt. When Mark refuses, Kiko pulled out his pistol and threatened Mark. 3 things to remember in light coercions are there must be a creditor, a debtor, and the debt. So, under the second paragraph of the light coercions, if the first and third element of grave coercions is present and the second element is lacking, it will fall under Article 287 or light coercions. Like for example, Kiko is renting on Mark's apartment and Kiko has no money to pay on his rent. Mark locked the apartment and put a placard for rent. So that is example of light coercion. Take note that it must not has a physical violence. Let's proceed on unjust vexation. Unjust vexations refer to any act that annoys or vexes an innocent person. There's a lot of examples of unjust vexations like stalking. Take note that it must not have a physical violence and sexual relationship. Penalties of light coercions is arresto mayor. Any coercions or unjust vexations shall be punished under arresto menor or a fine ranging 5 pesos to 200 pesos or both.
Article 280. Other similar coercions. Compulsory purchase of merchandise and payment of wages by means of tokens. So this article shall impose upon any person. Elements of number 1. That the offenders is any persons, agents, or officers of any associations or corporations. That he or such firm or corporation has employed laborers or employees. That he forces or compels directly or indirectly, knowingly permits to be forced or compelled any of his or its laborers or employees to purchase merchandise, commodities from him or from said corporations. Elements of number 2. That the offenders pays the wages or laborer or employed by him by means of tokens or objects. That those tokens or objects are other than the legal tender currency of the Philippines. That such employee or laborer does not expressly request that he paid by means of tokens or objects.
General rule. Wages shall be paid in legal tender, and the use of tokens, promissory notes, vouchers, coupons, or any other forms alleged to represent legal tender is absolutely prohibited even when expressly requested by the employee. No employer shall limit or otherwise interfere with the freedom of any employee to dispose of his wages. He shall not in any manner force, compel, oblige his employees to purchase merchandise, commodities, or other property from the employer or from any other person. For the penalty, any violation of the provisions of this code declared to be unlawful or penal in nature shall be punished with a fine not less than 1,000 pesos nor more than 10,000 pesos or imprisonment of not less than 3 months nor more than 3 years or both such fine and imprisonment at the discretion of the court. In addition to such penalty, any alien found guilty shall be summarily deported upon completion of service of sentence.
Article 289. Permission, maintenance, and prohibition of combination of capital or labor through violence or threat. This article is applicable for any person who commit the following elements. Number 1. That the offender employs violence or threats in such a degree to compel or force the laborers or employers in the free and legal exercise of their industry or works. Number 2, that the purpose is to organize, maintain, or prevent coalition of capital or laborers or lockout of employers. What are the penalties in this article? Shall be punished by arresto mayor and a fine not exceeding 300 pesos.
Article 290, Discovering Secrets Through Seizure and Correspondence. This article shall be imposed upon any private individual. The elements of the crime is number 1, offender is a private person. Number 2, he seizes the paper or letters of another. Number 3, the purpose is to discover the secrets of such other person. Number 4, the offender is informed of the contents of the papers or letters seized. The provision is not applicable to the parents, guardians, or persons entrusted with the custody of minors with respect to the papers or letters of the children or minors placed under their custody or care. If the secrets were not revealed by the offender, the penalty is arresto mayor with fine not exceeding 100,000 pesos. But if the secrets were revealed, penalty is prisión correccional in its minimum and medium periods and fine not exceeding 100,000 pesos.
Article 291, Revealing Secrets with Abuse of Office. This article shall be imposed upon manager, an employee, or a servant. This article can be violated if the offender is a manager, an employee, or a servant, and also if he learns the secrets of his principal or master in such capacity, and lastly, if he reveals such secrets. The secrets must have come to their knowledge by reason of their office or position, and it makes no difference that such secrets was communicated by the principal or master to the employee or servant. Let us note that the damage is not necessary under this article. So the penalty under this article is a penalty of arresto mayor and the fine not exceeding of 500 pesos.
Article 292, Revelation of Industrial Secrets. This article shall be imposed to any person. Elements. First, that the offender is a person in charge, employee, or workman of a manufacturing or industrial establishment. Second, that the manufacturing or industrial establishment has a secret of the industry which the offender has learned. Third, that the offender reveals such secrets. And last, that prejudice is caused to the owner. Prejudice or damage is an important element of this offense. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 100,000 shall be imposed upon any person mentioned in this article.
And yes, those are the contents of the Revised Penal Code Book 2, Title 9, Crime Against Personal Liberty and Security. I hope you gained some understanding from our discussion.